We're about to embark on a really, I think, unique experience. I've never done anything quite like this before, and I'm super, super excited for it. So anyways, this is the Ma'avar panel. For us to do a little introduction to the viewers. Ma'avar panel for Elijah Wiesman and Matan Kotler-Berkowitz, who are going to use their Ma'avar panel to argue their case before what would be an appellate court, the Supreme Court, with Justices Golden, Marks, and Bloom. So I want to thank the justices for joining us today. This is not just 45 minutes out of your day. It's a lot more time than that, because you have to read the brief beforehand in order to be prepared to ask the questions. So I'm really, really grateful to all of you guys for coming today. So I'm going to shut up and get out of the way. I think we have an opening statement, I believe, by attorneys Wiesman and Kotler-Berkowitz. And then we're just going to open the floor for the grilling, which I'm very much looking forward to. So I'm just going to listen. That's all I'm doing, and maybe chef a little nachas. Other than that, that's my job. So attorneys, take it away.
Great, thank you very much. Thanks for joining us. So in recent years, the Supreme Court has held that juvenile life without parole sentences are unconstitutional for most offenders. Following Miller v. Alabama and Montgomery v. Louisiana, states may only sentence a juvenile to life without parole if that juvenile is deemed irreparably corrupt and incorrigible. However, the court's not defined what they mean by incorrigibility or how a trial court should make such a determination, nor have they directed the states to do so. As a result, the incorrigibility standard is harmful and arbitrary, and thus unconstitutional. Our article discusses the history of children being treated differently from adults with regards to criminal punishment, and explores the vast scientific literature which demonstrates that incorrigibility is an unprovable and nonsensical standard to apply to children. Next, our article argues that these aspects taken together make the incorrigibility standard unconstitutional, both inherently and in its implementation.
First, the vague nature of the metric, as well as the impossibility of imposing the punishment in a proportional manner, violate the Eighth Amendment's prohibition against cruel and unusual punishment. Moreover, the current standards of decency in the United States and in the world at large demonstrate a strong objection to the continued implementation of juvenile life without parole sentences. In addition, the disparate implementation of the incorrigibility standard, due to a lack of regulation of the administrators, violates the Equal Protection Clause of the 14th Amendment. Lastly, our article addresses possible stare decisis arguments that may be raised in the course of overturning the incorrigibility standard, and argues that such a ruling would have neither significant stare decisis nor reliance issues. Indeed, such a ruling would actually resolve a current split among the lower and state courts, and would smooth over potential issues in the implementation of Montgomery. We now look forward to hearing your questions and feedback about our argument, and welcome any critique you may have.
Great. Judge Marks, would you like to go first, or do you want me to go first?
Please, Justice Bloom, take it away.
Oh, Justice, not Judge.
Sure, yeah.
Oh, no, we're at the very top, my friend.
Yeah.
Very top. That's right.
I have a few questions, Counselor. I'll start with Counselor Kotler, if you don't mind. I thought that you made some excellent arguments, and for the purposes of this exercise, I'm gonna assume that you're counsel representing Mr. Jones on appeal. My question about the arbitrary argument and the argument for the Eighth Amendment is that I think you make a few different arguments for the Eighth Amendment. One is the evolving standards of decency argument, and that one I think is particularly persuasive. How would you state a rule what would you ask the judge how would you state a rule under the Eighth Amendment's evolving standards of decency using the science that you have researched in this manner? How would you best argue the Eighth Amendment using the social science in involving standards of decency? If you were to go that route, the Eighth Amendment evolving standards route.
So in recent years, there's been a vast amount of scientific research regarding the development of juveniles' brains, which has revealed a lot about their neurological development, which we didn't know previously. And what this research has shown us is that there really is no way of determining whether a child who committed even heinous acts as a young child would necessarily grow up to continue to be committing these heinous acts and to never be able to be redeemed. While there are certainly children who do fit that description, there is zero scientific evidence that we can use to establish whether or not a specific child would be able to reach the metric. And it's also more generally understanding that children are generally less culpable because of their lesser understanding of the consequences of their actions, greater impulsivity, and things like that. Now, these things were not understood even 20 years ago, for example, before Roper v. Simmons, which outlawed the death penalty for juveniles. And gradually over time, as more and more scientific evidence of this come to light, states have moved to limit and restrict the amount of the harshness of punishments that can be dealt to juveniles. Now, the Supreme Court has also done this in Roper and then in Miller and then in Montgomery. But often what the Supreme Court turns to for understanding what the current standard of decency is turning towards states as a representation of the people's beliefs. Because as they've noted before, it's somewhat difficult to exactly establish what is a standard of decency for all of society or all of humanity. And so they can often turn to how states have dealt with these issues in the past. For instance, in Roper, they noted that 30 states had outlawed the death penalty for juveniles as a way of understanding that this was against the current standard of decency. And they've also in the past turned to scientific understandings of juvenile culpability as understanding that the death penalty specifically was no longer a standard that would meet the standard of decency. And so I think that in our current day, in 2020, a similar situation is in place with life without parole, because currently 23 states and Washington, D.C. Ban outright the death penalty, the life without parole for juveniles, largely because of the new scientific research that's come to light regarding that it's impossible to tell whether or not this child will be incorrigible in the future. And then also of the states that do technically allow this, there are very few of them, in fact, 2/3 of them are in 3 states. Very few actually implement this punishment. So I think all of these combined show that the United States as a whole, and by the way, the world at large, the United States is the only country that still has life without parole sentences for juveniles, to show that society as a whole has progressed past juvenile sentences without parole.
Okay, so that is persuasive to me, and I would follow up with your co-counsel that I think the rule under the 8th Amendment lane, if we just went through the 8th Amendment lane, would be something like it violates the 8th Amendment to label a juvenile permanently incorrigible, and therefore life without parole is unconstitutional as disproportionate under the 8th Amendment. So my question to follow up on this, let's say that's the rule that you got from the Supreme Court. My follow-up question for your co-counselor is, so then for all the, it was about 1,000 people, I think in your article said, had 1,000 individuals had juvenile life without parole, right? So let's say the Supreme Court says, as you argue very, very persuasively in your article, that this violates the 8th Amendment. And so it's no longer constitutional under any basis to label someone under 18 permanently incorrigible, and that sentence is unconstitutional. So then what is the solution for those 1,000 people? Right?
So, sure, for those 1,000 people who have already been deemed incorrigible on their rehearings after Montgomery, which necessitated a rehearing to determine incorrigibility, they need not have another sentencing hearing. All that the states would need to do is add parole to their sentence, the possibility of parole. So we're not saying that they need to be released from jail, but if the cruel and unusual punishment argument would stick, then they need to have parole added to their sentence. And then the parole boards can independently assess parole when the time comes for that. But there need not be new sentencing hearings for each of those cases that would put an unnecessary strain on the justice system for the end result to necessitate a life without parole, life with parole sentence.
Okay.
Justice Bloom, if I could jump in on this topic, and maybe we can stick with you, Attorney Weissman. I don't understand you and your co-counsel to be taking the position that there's no such thing as a incorrigible juvenile, but your primary concern is that there isn't any objective or reliable way to identify those defendants. Do I understand your position correctly?
That's correct, Your Honor. Yes.
So that raises an interesting question in my mind, and perhaps I'm a little more skeptical than my colleague. Sentencing inevitably involves subjective and moral judgments in addition to scientific judgments. I took a look at the list of aggravating factors in Mississippi for applying the death penalty, and among other factors, some of which are objective, are things like whether a crime was, quote, heinous or depraved, which I think are also not objective qualifications. So what's the basis, or maybe you can point me to authority that would help us understand why incorrigibility, as opposed to, say, heinousness, is somehow arbitrary or an insufficient standard under the Eighth Amendment?
Sure, that's a good question. So I think the answer may lie with the fact that the incorrigibility standard is for children, and so it's especially impossible to predict how a child will or will not develop, considering they're not even a fully developed human being when they're being sentenced. And while you're right that U.S. sentencing guidelines are generally not qualified for a void for vagueness challenge, as the court has held, the court's also held that when it's a really specific punishment being put on the defendant, that might be harsher than what a general sentencing guideline suggests. This is in Johnson v. United States, which was just a couple of years ago in 2015. There can be a void for vagueness challenge. In that case, it was, what does a violent crime mean? And incorrigibility is even more vague than what would a violent crime be. And it stands that juvenile life without parole sentences are the harshest sentence constitutionally allowed for juveniles. So as such, they would fall under an unusually severe punishment that could be subject to a void for vagueness challenge. So I think it's two-pronged. It's both the fact that they're specifically juveniles, while we acknowledge that judges may have discretionary authority to adjust sentences as they see fit. In this specific instance, because of how arbitrary it is, that it's being applied in a disparate manner, that goes to our 14th Amendment question as well, and that it's an unusually severe punishment.
So if you don't mind my following up, Counselor, on the Johnson point and the classification, I do understand what you're saying, that there are times where the Supreme Court says that a judge's discretion, even though all these terms, as my colleague mentioned, even though all these terms are subject to interpretation by the sentencing judge, in those cases that you mentioned in your article, which I did find persuasive, one of the problems was going above a statutory maximum. So it wasn't just that it was arbitrary. So you're right, the classifications can be arbitrary, but like a heinous crime and other things, those are decisions, or particularly brutal, that sentencing judges make every week, every day. In some of those where it becomes unconstitutional, it's often where a judge is infringing on a jury finding. So like in those cases, it violated the Sixth Amendment jury right because it was unconstitutionally, the labeling increases the statutory penalty. So I think your argument is persuasive under vagueness and arbitrary under both the Fifth and the Eighth Amendment, but I think what you're going to push against is the notion that a big part of the jurisprudence is that the sentencing judges have discretion in a lot of these terms. And this is different because it's not infringing on the statutory maximum. It's a finding that is particularly fact intensive by the judge who's closest to the defendant. And so that I think is an inherent tension in for me in the Eighth Amendment and the Fifth Amendment issues.
Sure, and I would also say that not having a factual finding of incorrigibility is actually going against Supreme Court precedent, whether or not state Supreme Courts want to admit that. Montgomery said that the judges are not allowed to just ignore the inherent attributes of youth or the incorrigibility of the juvenile if they're going to impose a life without parole sentence. Now, if they have no fact-finding requirement and they just say they've taken into account, they're essentially at will to ignore such a determination. And therefore, that really is beyond arbitrary. They're actually breaking with the Supreme Court's ruling, which is why it is the Supreme Court should be clarifying this to preserve the integrity of the justice system as a whole and to their authority over lower courts.
So we keep mentioning youth and juveniles. So let's go right to that issue for a minute, because as judges, as esteemed judges like we are, we're always concerned. Even persuasive arguments may establish rules that go farther than we're willing to go, or prove more than the attorney set out to prove. I have some concerns, and Attorney Kotler-Berkowitz, maybe you can help us with this. We keep using the word juvenile or child, and that means different things in different contexts. Some places it means 18, some places it means less than that. Sometimes it's a function of state law. But the social science literature, and you do a nice job marshaling that literature and summarizing it in your brief, suggests that the types of issues you identify that may make it impossible to predict incorrigibility are things that define a person's mind through the early 20s. Is it possible that you're telling us that someone who commits a murder, like in the case of it was either Montgomery or Miller, the shooting of a cop, the fatal shooting of a cop, when they're 21 or 22, couldn't be sentenced to life in prison because they still have a juvenile brain? Is that your position, attorney?
Thank you for the question. I don't believe that is our position. We certainly acknowledge that the same attributes that extend to children can extend beyond that into the person's 20s. But ultimately, as with any system that classifies children differently than adults, there has to be some cutoff. And for specifically criminal punishment, that cutoff has consistently been 18. And so we're not asking to extend that cutoff beyond 18. If we were, then we would perhaps start with trying to extend the death penalty beyond 18, because currently the death penalty below 18 is, in any situation, unconstitutional, regardless not of incorrigibility.
Well, but counselor, you're making a constitutional argument, right? So if it's unconstitutional for an 18-year-old to be subjected to life in prison because of the social science literature that you ably summarize, why isn't it equally unconstitutional to do that to a 19-year-old?
Or for non-homicide crime, how is that finding not going to prevent, for instance, many states allow 16-year-olds to be at the discretion of a sentencing judge, charged and sentenced as adults? So I think the fear that my colleague is saying echoes in that logic. So for example, if the developing brain is the basis for which this is unconstitutional, a problem becomes, how come some states can charge for non-homicide, non-life without parole, just, car robbery as an adult when you're 17? Wouldn't that logic then open a floodgate of other criminal litigation?
I think that floodgate has, in a sense, already been opened, and this would not necessarily be the one case that would tip it over the edge.
Right.
I think instead this case would be putting the court's logic inconsistency with the rest of its previous rulings, which all consistently held that when you're under 18, you have to be treated differently. And so, for example, in Roper, even though it's possible that somebody who is over 18 could have the same characteristics with the court, the same developmental characteristics which the court pointed to as the reason for making it illegal to sentence them to death, the court still held that they're not going to extend that prohibition to 19, 20, 21, because ultimately there does need to be a cutoff, and we as a society have decided that cutoff is going to be 18. I think this is an issue that is dealt not just with this, but with any system which puts a cutoff line between different ages, because clearly a 10-year-old is different than a 20-year-old, but between that it becomes murky. And so from a scientific and constitutional perspective, we kind of just have to make a definitive cutoff, and we have decided that that cutoff is going to be 18.
Justice Golding, would you like to ask a question?
I'm curious, as you look at this issue, do other countries or have other countries have had something that looks like the incorrigibility standard?
That is an excellent question. I believe at the moment, other countries do not sentence juveniles to life without parole, regardless. So currently there isn't such thing as an incorrigibility standard. I'm not sure if there has been in the past. As my co-counsel perhaps.
I have
Throw him under the bus. Well done.
a similar developed in this area. Yeah, but currently there would be no incorrigibility standard for juveniles for life without parole in other countries, seeing as it's not on the books in a single other country in the world.
And can you walk me through your understanding of how the standard is determined currently by judges? Is it purely judges' discretion? Do some states, do they go to a psychologist to determine this? How, or school evidence? How does the process actually work currently by your understanding?
So currently different states do it differently. And this is the split that we alluded to in our original argument. So post Montgomery, different states had to deal with exactly how we're going to determine whether or not a child is incorrigible. And what ended up happening is certain states said that Montgomery did impose a fact-finding burden. Whether that means a psychiatrist or looking at the child's past actions and circumstances where they were sentenced. And then other states have just said, no, Montgomery does not impose any fact-finding. It's completely up to the judge's discretion at will to deem a child incorrigible. And so, for example, right now in Mississippi, which is where Mr. Jones was sentenced, there is not a fact-finding burden, so the judge just declared Mr. Jones incorrigible in a very, very short ruling, which then just said, yes, he is indeed incorrigible.
And in those states where there is somewhat of a fact-finding necessity, when the forensic mental health experts are called in to testify to that, while they have tried to create some sort of metric to measure future reformability in juveniles, there's really a lack of reliable scientific literature to actually back those claims up. And so what they end up doing is making a determination about factors that may have been true in a large data set but aren't necessarily true within an individual about whether they're going to be incorrigible or not. Because as we've seen from the studies, even with adults, 95% of the future dangerousness predictions were incorrect. So they do try to make these determinations based off sociological factors and psychological factors, but since children can't be diagnosed with psychopathy when they're a child because it can go away as you mature and develop, there's really no reliable way they can make that determination. So forensic mental health experts are essentially stretching beyond their capacity as scientists, as they've been forced to by the court in those states which require a fact-finding requirement.
Thank you. And one quick follow-up, because I noticed in your brief you mentioned about the role of education and the role of race. Both struck me. And I know there's been a lot of research and studies about, let's take school suspension rates of students and the disparate impact that has on racial minorities. I'm curious about that literature and that thinking and that new discussion that's emerged, how you think that relates to the arguments that you're making here in this case.
So there's been vast scientific research that shows that African-American children especially are considered more culpable for their actions, whether that be a crime or a violation of a school rule. And that similarly carries over to sentencing decisions by judges. So what our basic argument is that there is a systematic and societal tendency to view African-American juveniles as more culpable, and therefore they're sentenced and found incorrigible at a much higher rate than their Caucasian counterparts. 72% of the children who have been found incorrigible are African-American, as opposed to the 13% of the population that's African-American, or even the 40% of the juveniles who are incarcerated who are African-American. Yeah, Justice Bloom, do you have a question?
Oh, sorry, I want to touch on this. So let's talk about the equal protection argument. Who's your protected class? Is it juveniles? Is it African American? Who are the protected class here? Do you think is most supported? So the disparate impact, I think you bring strong evidence to the table that this is disproportionately affecting minority youth and particularly Black youth. All this stuff is helpful. Would you agree that the existence of this standard is not intended as purposeful discrimination on the basis of race?
Yes, that may be true. However, the issue that we're pointing out here is not whether we're not making necessarily a intermediate scrutiny argument where you need to prove intent. Rather, we're saying that the issue is that it was left so open and so arbitrary to the administrator that there was the ability to inflict a disparate impact. And yes, we would say, I believe that the protected class would be based off race rather than age.
Okay. I think there's some support for just making the protected class minors in general. All the precedential support, showing Roper, showing Miller, all these ideas where juveniles are treated differently by the Supreme Court under the law. And then the disparate impact is look at the social that, although unintended by the creation of this bad standard, it has caused major racial disparities. So I think it's a great equal to protection argument. I think your protected class is one that's more strongly supported in the precedents, which is juveniles in general. I think that's your best protected class, and the disparate impact that is caused unintentionally by this bad standard. I think that's your best equal protection argument.
Dan, you're there you go.
Counselors, if I may, as the token Trump appointee on the, I'm less persuaded by what I see as a pretty radical extension of equal protection doctrine here. Putting aside the Eighth Amendment line of cases that you rely on, is there any precedent for treating juveniles with respect to criminal law as a protected class for the purposes of equal protection?
I'm not aware that there is, but that's primarily because in the past they've been firmly under the Eighth Amendment, because they've seen that the harsh punishments for juveniles is not necessarily an issue, or is first and foremost an issue of cruel and unusual punishment rather than disparate impact. Although I think that this is perhaps indicative just because this is more indicative of the fact that it's a criminal punishment, and so it's easier perhaps to file criminal punishment violations under the Eighth Amendment because they're just more closely related.
That was my understanding as well, and obviously we're all middle-aged adults here at this hearing, and so we'd all agree that for equal protection purposes, even putting aside criminal law concerns, I mean, we can do pretty much whatever we want to kids. They're not a protected class. I mean, the law imposes all sorts of burdens on children because they're kids. Isn't that right, Attorney Weissman?
That may be true, but if the law in question or ruling in question is so broad that it allows for the disparate implementation of it on children, then that's where it becomes an issue. And we have precedent showing that YICWO, which the issue was that it was so broad, has been applied in a criminal context as recently as 2013 by the circuit courts. So whether or not the juveniles in the past have been a protected class is in some ways besides the point of how broad the classification was and how undefined it was and left to the states.
I would think that a novel argument calling juveniles a protected class could find some support in child labor laws and other criminal fines imposed upon those who treat children adults. Or criminal laws that define a difference between children and adults for criminal penalties. I think looking into some of those would lend support to your equal protection argument. Although I agree with my esteemed colleague that the precedent supports more strongly an Eighth Amendment based argument. The criminal precedent.
Are there other questions from the justices? So I would love, if we could, to shift gears so that would, I guess, will formally end the oral arguments. And I guess one of my favorite parts of any moot court experience I've had for example, to watch Georgetown Law do the moot court is the afterwards, the unpacking. Like what did you find persuasive in what they were saying? What would you have them dig into a little bit more? Let's help sharpen this whole thing up and make sure they can go into the Supreme Court and win the next time. So we could do the seriatim or popcorn, however you guys want.
Yeah, so I'm happy to start what I hope will be a popcorn discussion. And I just want to start by saying I was really impressed by what you guys wrote. I mean, I've worked with like a lot of law students in big firms or recent law school graduates, and they don't write stuff like this. So it's for high school students to take on something so complicated and to make such a forceful argument in such a clear and well-organized way was really impressive. And especially since you're not law students yet, your sort of comfort and facility with legal doctrine and legal precedent was really impressive. So I think you guys did a great job, and I just wanted to acknowledge that, because it's something that takes usually people a long time to learn and to develop a comfort with, and you guys seem to have just taken to it like fishes to water. So well done. I think a couple things that I didn't want to sort of put in as our pretending to be judges, which is always fun, and I try to give you a little bit of like the pain of what that feels like. A couple things that sort of struck me while I was reading. One was, and this is sort of, I guess, my sort of almost ironic takeaway from how sophisticated you guys are about these issues is you start out saying that it's important for boomers like us who make decisions about kids and how they should be treated in the criminal justice system to hear the voices of juveniles. But ironically, you guys speak and sound like adults. Like if I had just picked this up, I wouldn't think you guys were in high school. So I think one thing that you could, I think, let rise to the surface a little more is what you feel like is sort of your unique perspective or unique voice, or the contribution that you guys have as teenagers who really might understand what it's like, to be a 16-year-old or a 17-year-old and peer pressured into a certain situation, or may say something, on social media that's exaggerated and crazy, but isn't really meaningful. Things that the grown-ups in your lives don't fully understand or appreciate, but that you have some unique perspective on.
Can I ask you a question about that? Do you think that would carry weight in the editing office of a law journal? Do you think that they would read that and say, that is a unique perspective, and we actually want to make sure that this kind of unique piece gets into our journal?
Yeah, I think it might. I mean, there's a lot of, we're living in the age of consciousness around intersectionality and, the rise of sort of affinity law reviews. And I think there's a lot of scholarship that says, I'm not just going to talk about the Eighth Amendment and evolving standards of decency, but I'm going to do it from the perspective of people of color. I'm going to do it from the perspective of women. And I'm going to have, a lens that I apply to this. You don't see a lot of juvenile stuff because high school kids don't write many law review articles, but I think there's definitely precedent for that sort of lens model of scholarship. And I think that's what you guys are really trying to do. And I think it would be an interesting contribution to the conversation.
I cut you off there. Were you going to say something else on top of that?
No, that's
great. That's very helpful.
That's my first kernel. So
very helpful. Thank you. All right, popcorn, jump in.
Right. I echo your comments that it was an extremely impressive article, and it was very well researched, and I could not believe that 12th graders wrote it. I don't really consider myself a boomer, but I was extremely impressed.
Yeah, Dan keeps accusing you. I don't know, man.
Yeah, that was for me. That was for me and John.
Listen, Karen. I don't know.
I don't know about the law journal perspective because I'm further removed from that. Although I do think that the way this reads is it could be. I don't know if you read with Mr. Cutton some of the amicus curiae petitions. So the supporter brief petitions. There are a lot of affinity groups who say this, Mr. Jones, re-petition to the Supreme Court based on the incorrigibility standard. A brief by educated children as amicus curiae, as friends of the court, They are non-interested parties who are informing the court of many things. Often those petitions have, so to me, it read both like a law journal and a petition for what's called an amicus petition, which you don't have they read some of those?
Oh, funny you should ask. So I don't know if you're noticing the looks on Matan and Elijah's faces, but I will let them respond directly to what you are saying. Gentlemen, take it away.
That was actually our original plan. Which is probably why it sounds a lot like that, because we went into this planning on writing an amicus brief for the Jones case. Now, in that case, the parties haven't granted blanket consent, and so we had to actually reach out to the lead counsel directly, and he ended up saying no.
No? The counsel said no?
Yeah, so partially, one of the reasons he said no, which is generally in these cases, he said you get a ton of amicus briefs, and they really want to go with the heavy hitters, which we took to mean was not two high schoolers. But then also because we actually, what Mr. Jones actually wants in the real world is just for the Supreme Court to establish a fact-finding standard, not to abolish the Supreme Court standard in general. And so our argument actually went beyond what he was arguing, and so we thought that would just muddle the waters.
Okay, so my follow-up is, first of all, this read like an extremely persuasive amicus, and I think that one of the things as a lawyer, I'm a defense attorney, as a criminal defense attorney, what I thought was really good was you have several different arguments, and you're giving the court sort of options on what to base or hinge its changes on. And I think that's something that we do in the law that we don't really do in that many other areas of life. Usually pick your best argument and go with it, but sometimes you want to find, and I really like that. I really like the different bases. There's a social science, and I thought that was really persuasive and read like an amicus. My criticism as putting my other hat on in terms of the workability of the rule, and maybe this is why they were like what the petitioner was looking for, is the one answer that I thought did not make, or the one sort of solution of just getting rid of the standard, and the way you would fix it in real life would be anyone who has this could just apply for parole, is that wouldn't work in practice. So in practice, the problem would be, let's say there are 1,000 people in the country and the Supreme Court says no, permanent incorrigibility is not a standard, that can't work. All those people need to have resentencing. They can't just become eligible for parole because, of course, they're at different points in their sentence. So it would be very arbitrary to just say, oh, they can now all apply for parole. So they would all have to have sentencings, which is fine. But then the question is, if there are those guidelines, can they, just like happened to Mr. Jones here, once post Montgomery, he had a new sentencing hearing, and they're like, "Yep, he falls into permanently incorrigible." If what he's asking for is these new criteria, I just don't think it's a workable rule to get rid of any of these. Allow them to apply for parole, because parole works differently in each of the state systems. It doesn't really exist in the federal system, and so it would require new sentencing for all of these people who are probably all now adults. So that part, from a practical point, I also share concerns of how this could be implemented with a rule that's forward-facing, and who would be able to be eligible for relief. Assuming it's a retroactive rule, like Montgomery made Miller, they could go through a collateral petition, but again, it wouldn't work to just make them all eligible for parole, because they're going to have spent different times in their sentence. I don't know. What do you guys think about the workability of that rule?
Do you want to take that?
Sure. Sorry. My answer wasn't very clear. I think what we were thinking was that they wouldn't all be eligible for parole right now. Rather, they all need to have parole added to their sentence at some point. But I guess I neglected to consider whether a judge can just sign a document saying they now have have parole added to their sentence at such and such a date, whenever it would normally be added for someone sentenced for a homicidal crime who did get parole. I guess that might again vary, but not that they would all be eligible for parole right now, but rather they need parole added to their sentence, which it's sounding like would need a new sentencing hearing to me.
What
is that right?
Yeah, that was a question. Sorry.
In Montgomery, the Supreme Court seemed to indicate that it would be possible just to add parole sentences. They have the quote here. Giving Miller retroactive effect does not require states to relitigate sentences, let alone convictions. In every case where a juvenile offender received mandatory life without parole, a state may remedy a Miller violation by permitting juvenile homicide offenders to be considered for parole rather than resentencing them.
Elisa, how does that line up with your initial question?
Well, again, I'm more well-versed in the federal system, but I guess parole is still discretionary. So then you're going to be faced with the problem if someone, the same judge says, okay, I have to allow him to be eligible for parole. Okay, I find under my discretion he's not eligible for parole. So parole, like in federal system, it's called supervised release, and parole is highly discretionary. It's based on this long-term belief that the judges that are closest to the criminal defendant are the ones that are best suited to make decisions for them.
So does that undermine their basic? Sorry, I mean, cut you off. Does that undermine their argument, or does it undermine just our basic system of parole?
I think my personal view is that it's part of the good and the bad of the criminal justice system, which is that there's a strong belief that regardless of the constitutionality, big picture of certain rules, the person who's closest to the defendant, the sentencing judge, is best suited to make those decisions. And we see a lot of these big headline Supreme Court criminal law decisions. We see a lot of these remands where it goes back down and the defendants get the same sentence because under their discretion, even without X rule, the defendant under the discretion of the sentencing judge. So it can be very unfair in the particular case. But of course, it is still great. Even when the change is positive for a criminal defendant, it's still good for defendants going forward that they're not going to be able to be eligible for life without parole. But oftentimes these big fancy Supreme Court changes result in, for the people already in the pipeline, getting the same sentence for reasons including stubbornness of the sentencing judge.
That's exactly what happened with Jones.
Yes.
Yeah.
Dr. Golden, love to hear your thoughts.
First, I want to echo my praise for you for the sophistication, the way in which you both wrote the piece and made the argument today. I walked into these proceedings with a lot of humility as someone who stopped his legal education with pre-law classes as an undergrad. So the one point I guess I want to raise, and I'm really curious for Dan and Elise to chime in on this too, is I was going back and forth about that, my first question about the international context. I'm wondering how that plays in the current legal, political environment. Do those arguments play in court? Would they play well? Would they backfire, given who sits on the courts? It's kind of I'm still left thinking about. So I'd love for anybody to chime in on that.
I certainly have a thought, but I'm interested to hear what you guys think, Elijah Matan, about the receptivity of our current court to arguments about what the Europeans think about this kind of stuff.
It's a good question. I will say that they have taken into account the international standards of decency in past rulings. So it's not a completely foreign concept. Now, you raise
No pun intended. Well done, sir. Go ahead. Sorry.
Yeah, right.
Now, whether or not our current court makeup would be willing to entertain such a proposition is not that I can read their minds, but it seems rather limited at this point, especially with where we're holding like recent rulings. But I think that my basic understanding is that the conservative justices have an issue with the idea of evolving standards of decency as a whole, because a lot of them are originalists, especially Thomas. So he thinks that the notion is made up in the first place. But since a lot of the justices, especially I think Roberts, are like really into respecting precedent because they want to increase the credibility of the court. Now that they have to follow the evolving standards of decency because their predecessors set that standard, I think now they're likely to take into account any number of factors to assess the standard of decency. And this one seems pretty glaring to me. We're the only country in the world to do this. It's not like 50 countries, including like Mauritania and Tanzania, have outlawed this. Like every other country has outlawed this. So I think it could be a compelling argument because they're kind of forced to take the evolving standards of decency into account. But I wouldn't I wouldn't bet any significant sum of money on that.
I hope that the petitioners for amicus and the actual litigants use the argument that I found very persuasive, which is that it contradicts mandatory compulsory education even for the incarcerated youth. I thought that was very persuasive as an argument, that it's incompatible with compulsory education and our philosophies, not to mention the precedents of Roper Miller and Graham, the Florida one. So I hope that they're not going to take this as a petition for amicus. I hope that those arguments, because I find them to be persuasive, that it's contradictory with every notion we believe in terms of educating and compulsory education.
Yeah, I actually think it's our next case. I think he's probably, this particular attorney I think has a long-term strategy. I think what he's hoping will happen is that the court will realize that there is just no possible, if the court orders that we have to go back and start doing testing for this, that eventually they will just be able to come back to the Supreme Court and say it's just not possible. We can't do it. And then the next case becomes the overturning case. So they may be a case too early with their attempts to throw in an amicus here. So
okay.
The lead counsel, David Shapiro, I think this is his third time bringing a cert on the exact same topic to the court. So this one got taken. I think this is basically like he's basically in charge of how this is going to go litigation-wise. So yeah, I think Mr. Khan's right.
Did he do Graham versus Florida? Did he do Graham versus Florida, the juvenile life without parole?
I don't
No, that's EJI.
Okay.
Yeah.
He picks up with the life without parole and incorrigibility issues. Yeah.
Okay.
He also alluded to the possibility that this argument would find a better audience in the future. We called him and he briefly said that even though he's not going to take this argument, in say 20 years, there will be more of a platform for this.
Dr. Golden, we ended up in a brief, aside based on one of your questions. I don't know if you had other feedback or any thoughts you also want to.
No, thank you. That's good.
So I just want to say that we're a little actually over time, but this conversation is why I wanted to record it, because these are the sorts of conversations that we want to make sure that we have for posterity, because this is what learning, I think, looks like at its best. This is what Mavar looks like at its best. Is you take two students with a passion who really want to make a difference in the world. You basically let them go and you say, use your talents and use all the skills that you have acquired in your years at Gann Academy and make something authentic and make something really high level out of this, and then invite the experts in the field in to come test it. And I got to tell you, it's beyond shipping nachas right now. So this is just incredible, guys. So Matan and Elijah, our conversation will continue, and we're going to talk about obviously next steps and taking, I think, the really, really helpful feedback from our three justices. I took some notes. You guys took some notes. We'll sharpen this. And then I would invite Justices Golden, Marks, and Bloom to read the article when it appears in the journal, whichever journal eventually does take this. We'll certainly send you an autographed copy. But I want to thank you guys so much, Dan, Eliza, John, for joining us. This was an above and beyond kind of panel for Mahavar to take the time to read it, come up with the questions, and ask and spend the time beyond time now in conversing with Eliza and Matan about this. It's so powerful. So thank you guys.
Thank you guys.
Thank you.
Very much.
So much. So much. So anyway, with that, we'll call bang the gavel. We're done.
Yeah, we'll take it under advisement.
Take it under advisement. Exactly. Exactly. So thank you guys so much again, and I look forward to Elijah Matan keeping this going. So have a wonderful day, everybody. Thank you so much. All right.
Thank you.
Bye, guys.